First District Court of Appeals now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon, and welcome to the First District Court of Appeals Zoom oral argument session. We have one case on the docket today. It's the City of Jacksonville versus Dames Point Work Boats, LLC, and Florida Department of Environmental Protection, case 19-1728. I see that all counsel are present. Mr. Teal is counsel for the appellant. You may proceed when you're ready.
Thank you, Your Honor. May it please the court, Jason Teal with the Office of General Counsel representing the City of Jacksonville. And if I could, Your Honors, I would like to reserve 3 minutes for rebuttal.
Noted.
Thank you, Your Honor. This appeal is limited really to 3 things. The first thing is that the city, in the case that was below, which was an application filed by an applicant in Jacksonville to operate an industrial tugboat operation from really 4 parcels in the city limits of Jacksonville. The city petitioned to challenge the issuance of the dock permit, as well as the sovereign submerged land lease that was applied for to do this tugboat operation. So the appeal is limited to 3 things. The first is that the city was inappropriately prevented from providing evidence that the incompatible upland zoning of 2 of the 3 parcels with the docks on them weighs against the public interest benefits of granting the sovereign submerged land lease. The second thing is that the applicant failed to provide reasonable assurances that it met the requirements of the environmental resource permit by failing to provide any evidence that it possessed the financial capability of appropriately constructing the project. And finally, the third is that the trial court and FDEP improperly applied the burden shifting requirement from section 120.569 subparagraphs 2P of the Florida statutes.
Counsel, if I could ask, what is the status of the project right now? Is it being built? Has it been built? What's the status?
The status of the project, Your Honor, is that it is currently in the process of going through permitting. They did apply for an administrative deviation from the city, which my understanding is that they were granted in order to afford them to be able to use the maximum amount of land possible for their 1 industrial zone property.
Because I think weren't there 3 residential and 1 commercial that they own? Or there's 4 lots together. I thought there were 4 lots.
You're standing in the river. If you're looking at the property from right to left, there is a residentially zoned property. Next to that is an industrial zone property, and then 2 residential zone properties to the far left. Each of these properties is about the size of a normal residential lot. And so they're all pretty much about the same size, but correct, there is 3 residential lots and 1 industrial. It's kind of in the middle of it all.
Okay.
So the first.
Well, if I could ask you, getting right into the meat of the arguments, it appears to me as if the case law basically says that zoning and sort of local matters such as that don't matter unless there's a state statute that says they matter. And it may well be that you're right, that common sense says that the city ought to be able to put in its zoning and say the hardships that'll befall the city. But doesn't the state statute have to say that those considerations were permissible in this context?
Your Honor, that's a good point. The state, first of all, we have to recognize that the whole premise behind sovereign submerged lands is grounded, or bad pun, sorry, in the Florida Constitution that talks about that these sovereign submerged lands are held in the public trust for the benefit of the public, and that in order to take them out of that public access, public trust, there really needs to be a demonstrable benefit that outweighs the costs for the activity. And so it all stems really from that particular premise under the Florida Constitution that it has to be this balancing test. Now, that balancing test is in the statutes. What we're saying is that this analysis of the upland zoning was required to fully evaluate the environmental, the social, and the economic benefits versus the the associated costs. Our position is that the upland zoning, for the reasons we'll discuss, should have been evaluated as far as the determination. The only benefit really that was determined for this particular project was the jobs that would be created through the operation of the tugboats. Our position is when 2/3 of those docks can't be legally used, that goes towards whether or not that economic benefit is fully realized. It goes towards what societal impacts are going to be associated with, the city having to exercise its police power to enforce any violations of the upland zoning. It all goes towards whether or not the footprint of the sovereign submerged lands is appropriately established. When, is there a need for example, the adjournment from the land out to the dock itself, if the land itself can't be used to access it?
Council, let me ask a follow-up question on that point. In Workboat's answer brief, they represent that it remains to be seen whether Workboats will use the uplands in a manner that will require the city to incur any costs for future code enforcement, the argument being that any injury is therefore speculative. Would you please address that?
Sure, Your Honor. The reason why they're in a catch-22, and the reason they're in a catch-22 is because either they're going to use the docks, and if they do use the docks, then they will be in violation of the zoning code. Or if they don't use the docks, then they haven't met their burden of demonstrating that the benefits outweigh the harms. So the reason being is that they're pursuing this as a sovereign submerged land lease. So by pursuing it, they're admitting that they have a need for it, that there's a good reason to encumber the sovereign submerged lands and take it out of the public's use. So our point is that we weren't even given a chance to even factor that in, to have the court weigh that in, to have the department weigh that in when coming up with its recommendations as to whether or not to approve not only the footprint that was established by the applicants that's being requested, whether it should be approved at all or whether it should be reduced in size.
Well, other than the incompatibility with the zoning code and your cost of enforcement by the city to enforce the zoning code, what other evidence would you want to put in?
Well, I think that's the other evidence, Your Honor, that goes towards another part of the analysis, which was the burden shifting piece as far as the demonstration required for the environmental resource permit. I think for the sovereign submerged land lease piece of it, that's all the evidence that we would want to put in is what impact would the upland zoning have on the public benefit or the public cost. Turning towards the environmental resource permit, the evidence that we would want to put in before the trier of fact in this case is the lack of any demonstrable evidence that's been submitted by the applicant to prove that they have the financial assurances to complete the project.
Let me ask you on that. I've looked at the record. I haven't seen anything in there that remotely supports a financial capability to construct the facility. I may be missing it. The other side can tell me where I've missed it. But it looks to me as if, well, even DEP, the representative testified, we don't look at financials. We don't determine financial capability. So it looks to me like the rule says they have to put in something to show financial capability, but it's toothless because no one really looks at it. Am I accurate or am I off base?
Well, I think that it's not supposed to be toothless. I think that the way it's applied makes it toothless. And the reason I say that, Your Honor, is because this all starts with Rule 62-330.060, which is the content of the applications. And the content of the application is supposed to be the application that the applicant fills out, the processing fee, and then the last thing is the part that I think gets overlooked, which is other information needed to provide reasonable assurance that the proposed activities meet the conditions for issuance. The conditions for issuance is established in a different rule, which is 62-330.301, and that says that the proposed project will be conducted by a person with the financial, the legal, and the administrative capability of ensuring that the activity will be undertaken in accordance with the terms of the permit. So what you're hit the nail on the head, Your Honor, in that in essence, what DEP focuses on here is they focus on a specification in their handbook that says that compliance with this requirement, meaning the financial, legal, and administrative capability demonstration, must be demonstrated through subsection 62.330.060 sub 3. All right, so none of that has to do with any financial assurances. So our point is that in order to qualify, it's well established in permitting laws that if the legislature establishes a number of criteria that must be affirmatively met, the failure to provide evidence to support any one of those criteria demonstrates a requirement to deny that permit. The city raised this issue at numerous times during this whole proceeding that there was no evidence of any financial assurance. And what we did is we provided that it was a motion, subject of a motion in limine, our, during the hearing, our petition, our proposed recommended order, all of that indicated all of that. So we think that's a fatal flaw because of the fact that these criteria can't be without some kind of, the legislature doesn't put it in there unless it means something. So for it to be toothless, you have to have acknowledged that it exists in the first place. While they pay lip service to the fact that it exists because it's in their rule, they stop at, these are the only things that we require in our application, and there's no ability or need to supplement that with any additional evidence. I think that's a mistake and a misread of the rule, because the rule actually says those three things: the application, the fee, and other information needed to provide reasonable assurance that the proposed activities will meet the conditions for issuance.
Well, the rule requires financial information of some sort, I assume, but there's nothing we can look at that specifies exactly what that is. Does there have to be an estimate of the project cost? Does there have to be a certification that this company is solvent enough to have the resources and so forth? Is any of that in the record?
None of that's in the record, Your Honor. And the city's position on that is, we asked for what's the estimate of the cost of the project. We asked for what funding do you have in place in order to make sure that these financial assurances are present. I think it's important, that they demonstrate financial assurance. Reason being is because the last thing that the city wants, that FDEP wants, that the residents out there want, is somebody to get halfway through their construction, run out of money, and then leave a half-constructed dock that's subject to hurricanes, blight. It could serve all sorts of ills that, people running into it, it's not lit, those kinds of things. So it's an important concept to demonstrate financial assurance that you have the capability of appropriately constructing the project, not only finishing it, but also making sure that any conditions that are associated with it are also applied. So,
Counsel, let me just put myself in an applicant's shoes. If I'm an applicant and I read the rules and I read the handbook that's incorporated into the rule, provision 1.5.1 spells out the documents, the information that must be submitted in order to comply with 1J of 62. And that happened here. The ALJ found that the application was complete. I don't think there was any exception filed to that. So as the applicant, why has there not been a prima facie showing of a completed application?
Thank you, Your Honor. The reason why we think that that it's insufficient is that we acknowledge that the application is the application. We're not certifying that it's sufficient. When we stipulated that is the application, we stipulated, yes, that's what they submitted. But we pointed out at every level of the underlying case that it was insufficient. Where we think that the court misapplied the burden shifting requirement is because, in essence, what they said is, city, you're required to prove a negative. You're required to prove they don't have the financial assurances to be able to complete the project. That's not our role here. It's common knowledge when it comes to permitting requirements that an applicant must demonstrate they can affirmatively meet all of the criteria that are required in the permit. The burden shifting is they do the prima facie case by establishing, yes, this is what we submitted. We respond to that by saying, but what you submitted doesn't meet the requirements. That's the burden shift. Then the burden shifts back to them to say, well, but no, you're wrong, because here's what we submitted and here's why it meets the requirements.
But I guess this kind of goes back to Judge Makar's question. What do you contend an applicant must put in the application to meet the financial requirement? There's nothing listed in the handbook but for the 3 items that they did submit.
Well, I think that the applicant's handbook doesn't have to spell out in excruciating detail exactly what has to happen, because the facts of every particular applicant are going to be different. The requirements are going to be different. How you meet them are going to be different. For example, this applicant may have presented financial assurance that says, we have a loan that we're going to use to construct this, and the collateral for the loan is going to be dependent on the pro forma for our business as to we're going to generate this income. That dovetails back into the whole upland zoning issue, because the whole point is that if that was how they demonstrated financial assurance, well, but 2/3 of your docks can't be used for the intended purpose, potentially. So how does that affect your financial assurance? So the rules don't also contemplate how you demonstrate sufficient upland interest in property. It doesn't spell out how you have to meet, what evidence you have to present in order to meet that. That's why there's a trier of fact, because the trier of fact looks at what was submitted and evaluates it, and whether or not that meets the requirements and whether you've sufficiently demonstrated what you're required to demonstrate. Our point is there's 0 in there. There's nothing to evaluate. We think that's a fatal flaw. So we're not asking this court. We recognize that the whole thing with standing and we have to demonstrate that we're adversely affected. We're not asking this court to look at the determinations made as to whether the evidence was sufficient. We're saying there was no evidence, therefore there's a misapplication of the law, and that in essence there's a miscarriage of justice that happened at the lower tribunal in this case. We think that we can get there because of the fact, and that trust me, that the other 2 parties are going to focus a lot on standing. We think we get there because of this court's decision in the Environmental Confederation case from 2003. Now, that case dealt with an applicant that was denied standing to even participate at DOA. But what we want the court to understand and to have the determination is the court applied the reasoning that an adverse effect can also be created through decisions that are made during that administrative hearing process. In that case, it was that you don't have standing. In our case, it was that there's a misapplication of the law, a misinterpretation of the law, and in essence, it arrives at the same point. Because the reason I think that's important is, let me point out, you get to the whole parade of horribles and how this could play out. Let's say that, okay, the legislature established that local governments like the city can participate and have full party standing at these DOA proceedings. We met that. There's no dispute that we have standing to participate. But within that administrative hearing, let's say that we were denied the ability to cross-examine a witness, or we were denied the ability to present evidence. We were, in essence, our due process rights were violated. If you go with the state's interpretation and the appellee's interpretation, there'd be no way to have that looked at. There would be no ability for us to challenge those types of violations that happened during the trial court, because we can't show a concrete and particularized injury to one of our interests that's going to be impacted by the granting of the permit. We don't think that that's appropriate. We think that the rationale from the Environmental Confederation case can be extended in these instances where there is, in essence, a miscarriage of justice because the essential requirements of law weren't met. Totally borrowing from certiorari review, second tier, first tier certiorari review.
Counsel, and I'm sorry to interrupt you, but you are well past your expiration time. And so what I'm going to do is I'm going to provide 2 minutes for your rebuttal. And if I'm looking at the clock correctly, that is to extend the other side 5 minutes. So if you want to divide the time 10 and 10, or however the appellees would like to do that, I will defer to them. But I'm now going to turn it over to the appellees for their argument.
Thank you, Your Honors. To the time, I think we would agree to split it, the additional 2 minutes. Your Honors, may it please the court. The final order in this case should stand. To support this position, the department would like to address three main issues today. The most important being the fact that the city does not have standing to bring this appeal. And should this court find that the city has standing, the remaining two issues would be that zoning was properly excluded from the proprietary public interest consideration, and that the department and ALJ did not err in interpreting the requirements necessary for financial assurance.
Well, counsel, isn't the standing issue interrelated with the merits of the two issues the city has raised, or at least the two or three issues the city has raised? Because, you know, if we agree with them, for example, and I'm not saying we will, but let's say we agree with them about the financial capability issue. Well, don't they thereby have standing to appeal that issue to get it resolved? I'm sort of struggling with this idea that somehow at the very outset, we can make a judgment about the merits of the claims they raise to say, well, that's not really significant enough to raise. So therefore, they don't have standing. It seems circular what you're arguing.
Yes, Your Honor, but no, that would not rise to the level of standing, because what they're pointing at is procedural. They're pointing to, you didn't consider this, or the judge ruled this. These are not things that adversely affect some sort of protected environmental interest, which these proceedings were limited in scope and designed to protect.
Well, I mean, let's say the city wanted to put in evidence that this new facility with all the boats that'll be there is going to put a strain on the marine fire facility just up the river. They're going to have to really expend more money to have more marine fire boats and so on and so forth. And ALJ says, no, that doesn't come in. That has nothing to do with the sovereignty lands, blah, blah, blah. But the city says, wait a minute, that's going to impact us if this big facility is there and has this potential for adversely affecting the city's budget. Why can't they raise that on appeal?
Because, Your Honor, that would be economic in nature. Again, you know, the city can participate, which they did. However, the example and also their argument relies around a wholly economic injury. And there's substantial case law to support that, you know, this 12057 proceeding does not protect economic injuries or consider local comprehensive zoning.
Council, can we move to the issue of the financial capability under Rule 62? What do you think is the meaning, or what is required? What is the purpose of the language financial capability?
Yes, Your Honor. And to that point, the applicant's handbook is actually adopted and in rule. And so the requirements of the applicant handbook and the requirements of 1205692P simply require that we demonstrate that all the reasonable assurances required by rule are provided. And according to our handbook, that was met. And the administrative law judge also made a finding that that was met.
So your argument is that the handbook trumps the plain language of the rule?
No, Your Honor. We're arguing that the handbook, in conjunction with that and the facts presented at the hearing, proved that all the reasonable assurances required were met, and the department met its prima facie case, shifting the burden.
What evidence, if any, did DPW provide regarding financial capability, whether cost of the project, any financials whatsoever?
Yes, Your Honor. So in that analysis, it's tied to Upland ownership, and they provided a warranty deed stating that they had the sufficient title to the uplands to access the state lands. They also signed the application stating that they would be able to convert this into the operation phase. So in order to convert this to the operation phase, they would have to complete it, which would remove the fear of the city that it would be left uncompleted.
Well, isn't that argument sort of mutually exclusive? So for the analysis of zoning, your argument is that sovereignty lands, water is separate and apart from upland zoning, can't be considered, but yet now you're arguing use of the upland is considered in financial capability analysis of the sovereignty lease and works. So how do you mesh those two? Aren't those mutually exclusive arguments?
Just one clarification, Your Honor. We're arguing that you have to have the sufficient upland interest. And sufficient upland interest is the ownership of the uplands. It's not tied to a use or the allowed activities. That's tied to being able to access the water and have riparian rights.
Yeah, but
So-
council, that has nothing to do with financial capability. I may have a wonderful deed that shows I have an upland interest, but how does it show I have the financial capability to get the project done?
Yeah, Your Honor. And again, we would just point to the handbook and the determination by the administrative law judge that everything that was required was provided. And we can't
Well, just because an application is complete doesn't mean that you automatically get your permit. I mean, it's sort of like you applied to the Florida bar to become a lawyer. You've completed your application, but they've evaluated it and you fall short on something, perhaps. Not you, obviously, but you're a member of the bar. But but it's complete. But so what? Is there absolutely no qualitative analysis of what's submitted to make sure there's a financial capability?
There was none required, Your Honor. And again, we would just rely on the handbook that stated that those rules are met by providing the information that was provided in the application.
Council, interestingly, you point to the handbook, and the title for that provision is administrative criteria, ownership and control. And what the appellant is arguing, it's the financial information that's missing. And so perhaps one argument could be made that perhaps this provision of the handbook isn't really designed to tie into the financial assurance requirements. If you could respond to that.
Yeah, Your Honor. There's applicant's handbook section 151, which refers to saying that this will be sufficient to demonstrate compliance with 0603, which is the sufficient upland property, in 0604, which is operation and maintenance. And then there's also section 12 of the handbook, which is the form that's required. And that form was argued to have met that requirement and was all that was required by the handbook.
But again, I may have miscommunicated my question. The title for this requirement is administrative criteria. It doesn't signal that this is a way to fulfill the financial assurance requirement of 62 IJ.
Yeah, and in the rule, it says that it's the financial, legal, and administrative, so those all might be addressed under that same section from the same rule.
But it's all I'm not hearing the answer to the question. It's administrative. It has nothing to do with financial. No?
Your Honor, we would argue that that administrative evidence ties into the financial because that's what was required by the handbook.
Does DEP ever look at balance sheets, income statements, and looking at
No,
the
Your Honor. We did not consider or require that in this instance.
So you are approving permits around the state, potentially with companies that could be on the verge of bankruptcy. They don't have the financial ability to complete the projects. Is that what you're telling me?
Your Honor, as part of getting a sovereign submerged lands lease, they have to sign an affidavit saying that they have the billing information and that they're not subject to a bankruptcy proceeding. So as far as the submerged lands lease, that is required. But so as far as bankruptcy, that's been addressed.
Okay. It just sounds like you as an agency don't look at financials at all, other than you're not in bankruptcy.
Yes, Your Honor. To the standing argument, the city attempts to allege that they're adversely affected by the potential increase in the cost of zoning enforcement. This fails to rise to the standard of adversely affected because not only is it speculative, it's economic in nature. As this court has determined before, economic injuries are not of the type or within the scope of interest that these proceedings were designed to protect. As also found in this court in Martin County Conservation Alliance, the inquiry for standing is whether legitimate environmental interests were adversely affected. Again, the city has failed to identify any legitimate environmental interests. The city also attempts to argue that they were adversely affected because they were prevented from presenting a substantial portion of their case. The city's claim is based on the perceived error that excluding evidence of upland zoning. The city attempts to extend the finding environmental confederation as the basis for this argument. As the city stated earlier, the Environmental Confederation Court found that the parties were adversely affected because they were denied the right to petition or initiate a challenge. In this case, the city was not denied the right to participate. The agency action, they fully participated at the lower court. This is completely distinguishable from excluding the city from presenting wholly irrelevant evidence at the administrative proceeding. Even if this court finds that their argument is persuasive, a party cannot or unable to prove that it was adversely affected by the agency action cannot rely on procedural error alone.
Counsel, I'm interrupting only to let you know that you are into your, not co-counsel, but the other counsel's time if you wanted to defer.
Your Honor, I will go ahead and defer. Again, we would just suggest that the final order stand. Thank you.
Thank you.
May it please the court, Sid Ansbacher for LE Dames Point Workboats. I just want to emphasize one thing that Chief Judge Ray noted. The applicant's handbook is not a policy as noted in the reply brief. It is a rule. It was stipulated to as a rule. It's incorporated by reference at Rule 62-330-10 sub 4 sub A. The applicant's handbook at 151 specifically notes that compliance with the financial, legal, and administrative authority must be demonstrated through the 62-330-060-3 and 4 certificate required in the application form in section 120 of the handbook, or excuse me, 120 of the handbook. And I just have to emphasize that is a prima facie application. And please understand that the brief that we provided emphasizes that the burden under 12569-2P flips then to the city to provide any competent substantial evidence that we don't meet financial assurance. Had they done so, we would have been able to respond. For example, Mr. Teal in his argument says, what if there's a loan? The record reflects there's no loan. We have an engineer, our client is a veteran Marine contractor who is building docks. This is a very straightforward application. And it is our contention that under the burden shifting, we met what the rules in paramateria required of us for a prima facie showing. And we're fully prepared. Had the city done anything other than make legal argument before, motion practice, and arguments post-hearing, what did the city do? The city simply asked on cross-examination of Tom Calamine, who was the DEP witness, did you ask for anything more than summed up what the applicant's handbook required? The answer was no. Nothing was followed up.
Counsel, how do you define financial capability in Rule 62 then?
You do it predicated upon a review in paramateria, at least for prima facie entitlement, filling out the forms that are called for in that rule. If, for example, there was a question, how much is it going to cost? It's not in the record. I know how much it is, and I could have elicited that of my client, but that was not asked. What conditions are there to this project? There was nothing in the record, but again, we could have stated whether or not there would have been any subs, and again, the record already reflects there's no loan. So the answer is, had the city presented any competent substantial evidence, as was its right under 569 2P.
Well, I understand that, but I think the city's arguing there's no burden shift, that it's your prima facie responsibility. So my question to you is, under that context, how do you define the reference to financial capability in Rule 62 as an applicant?
It is an intertwined obligation under 151 in the applicant's handbook. The prima facie showing is defined as showing that we have sufficient upland title and that we certify to the specific certifications that are called for in 151 as well, and that's sub 3. Sub 4 is that we have provide an as-built certification, request for conversion, and operating permit, which the recommended and final orders both said are provided reasonable assurance because those are obligations that are prospective at conversion from construction to operation and are obligations of the consolidated notice of approval by the DEP. And again, the city never did anything beyond simply asking if we had done.
Well, neither
anything.
did the DEP. This is sort of got my mind in a tangle, because no matter what you put in, you could have put in the wonderful financial documents, but DEP didn't do anything with them. So I'm getting really struggling here to figure out, how does this really work? It sounds like I could build a dock tomorrow by filing an application and filing one page that certifies that I have the financial ability to do it, but no one actually looks at it. No one seems to, other than the city in this case.
Your Honor, whether they would or wouldn't, all I can tell you is it was undisputed and unaccepted from that we met that initial burden.
Well,
and
I thought I heard him say that they understand you submitted a complete application, but what they're contesting is that on the issue of financial capability, there's zero substantive evidence about it, only a certification that your client, I guess it was a one page that I hereby certify I can build this financially.
It's Your Honor, it's several pages, but be that as it may, again, it was incumbent upon the petitioner to say that that wasn't enough and why.
Was there discovery?
There was discovery, and there was discovery provided. That's why ALJ Sellers was able to say that the client or our client was going to be doing the project as a marine contractor with an engineer having certified, and that there was no loan.
What financial documents were disclosed by your client?
I don't remember down to the molecular level, Your Honor, but there really were fairly few because, again, this was a cash deal by a marine contractor who was going to be essentially extending 3 docks by the terms of this particular permit and putting in several dolphins. This is not the most complex of projects, Your Honor. So with that in mind, I would simply go back and note, in fact, Judge Makar, I just on the other issue, to the extent that I have a minute and a half, you were on the winning side, I was on the losing side for Stop the Beach Renourishment, Mazel Tov, but you understand, and from having appeared when you were Solicitor General, Article 10, Section 11 of the Constitution directs what we are to do with the submerged lands lease. We are looking at public trust ownership that is held for the public's navigational and recreational natural resource use, not an upland zoning use. The upland zoning issues are wholly irrelevant. We cited at length to the cases that so state, And the case law is unbroken. Most of the case law, ironically, is over in the regulatory side under 373 and predecessor statutes in 403. But it's even more definitive. The case law, Mariner Point and others cited by the petitioner as well as us, state that the public trust doctrine, while it is a very lofty standard, is physically constrained by those submerged lands. And with that, because you've been kind enough to give us additional time, I close by concurring with Ms. Lewis by asking that you affirm the decision below. Thank you.
Thank you, counsel. I'll turn it back to Mr. Teal.
Thank you, Your Honor. Really wanted to address a couple of points. One is, it seems as though the court shares the city's confusion as far as what is the requirement in there for, is if all they're going to do is to provide, what's in the application and that's sufficient. But I'll direct the court's attention to the 120.569 sub 2P of the Florida statutes. And what that says, that talks about the appeal itself, the challenge. It says the order of presentation in the proceeding is for the permit applicant to present a prima facie case demonstrating entitlement to the permit, followed by the agency. This demonstration may be made by entering into evidence the application and relevant material submitted to the agency in support of the application. This contemplates that there should be something more than just the application itself. There should be something in there that is relevant material that's presented to the agency to support the application. And if it's presented to the agency to support the application, by definition, it means it has to be presented by the applicant. So it clearly it contemplates going beyond just what's in the application. The second thing is that what they're arguing here is that it was up to the city to dig into the appellant's checkbook and checking account to see if they have enough money to pay for this project when we really don't have any idea how much the project is going to cost in the first place.
Is that not reflected in the record, even the cost of the project?
The cost of the project is not reflected in the record. So what this burden shifting they're saying is that we have the burden to prove this negative when who's in the possession of the best information to be able to convey that particular component of this application. The last thing is, Your Honor, is that when they say that the upland uses are irrelevant, DEP looks at upland uses for residential docks, multifamily docks, all kinds of docks where they require upland, the upland uses. With that, I appreciate it, and we would request that the item be, overturned. Thank you, Your Honors.
Okay. Thank you to all the attorneys that participated today. We appreciate the excellent advocacy. The court is now adjourned.
Thank you, Your Honor.